Welcome back. Welcome back to Kenton and Habiba. This is going to be a very serious topic. Did you hear about the woman, the pregnant woman that is being kept alive in Georgia due to the Georgia heartbeat law? This woman has been declared brain dead, but she is being kept alive because of her pregnancy. So let's talk about it. It raises a lot of interesting ethical questions, and also just very disturbing when you hear the case. So I'm just going to go ahead and read a bit of the story for those who don't know. 30-year-old Adriana Smith was about 9 weeks pregnant when she started having bad headaches in February. So she's 30 years old and she's 9 weeks pregnant. She started having headaches back in February of this year. So according to her mother, April Newkirk, she says that her daughter went to Northside Hospital for help, and that per her mom, she was given medication, but they didn't do anything. In terms of tests, they did not do any tests. Did not do any CT scans or any tests. Gave her medication, sent her home.
Quick side note, it's not the standard of care that everyone who shows up to the emergency room gets a head CT because they come in with a headache. No, that is not the standard of care to expect a head CT for every headache. Most people will be treated with medication unless they have some sort of red flag. So again, the ER's job is to distinguish whether you have a primary headache or a secondary headache. So for example, if you're used to getting tension headaches or migraine headaches, you're better off seeing your primary care provider or a specialist instead of going to the emergency room. Now, in the case of this 30-year-old pregnant woman showing up to the ER with a severe headache, we can only assume that either one, she did not exhibit anything that suggested red flag, or two, she did not have a proper history in physical and neurological exam, or three, the hospital did not follow the proper protocol and she was just not taken seriously.
So the next morning, the boyfriend noticed that there was something terribly wrong and she was gasping for air in her sleep. She was gargling, and she was then taken to Emory Hospital in Decatur. So then she was transferred to Emory University Hospital, where she worked apparently as a nurse. But unfortunately, the doctors could not do anything for her. So CT scans show that she had blood clots in her head. Now, this is per the mother. She had blood clots in her head, which I would just assume would mean that she had had some sort of stroke. Because if you have blood clots in your brain, it suggests that you had interference of blood flow to the brain tissue or brain matter, which caused obviously significant traumatic brain injury. Also, it's important to mention that blood clots during pregnancy can happen anytime during the pregnancy and even up to 6 weeks after the pregnancy. If you have any swelling and pain in an arm
or leg
while you're pregnant, or severe headaches, you should definitely see your medical provider about that. So the CT scan showed that she had blood clots all in her head, and the doctors declared her brain dead. The mother understandably feels that one of the hospitals dropped the ball because apparently the first time they went to the hospital, the boyfriend asked, please keep her. He asked for them to keep her in the hospital, and again, they sent her home with medication. The point is that the family feels that they were not given any say in what happens next because the hospital decided to keep her on a ventilator despite the fact that she is brain dead because of Georgia's heartbeat bill, which bans abortions after a fetal heartbeat is detected.
Because of Georgia's heartbeat bill, which bans abortions after a fetal heartbeat is detected, the family says they weren't given any say in what happens next.
It's torture for me. I come here and I see my daughter breathing by the ventilator, but she's not there. And I'm touching her. And she has a son. But my brain is see her.
Now, 21 weeks pregnant, her baby's health uncertain.
She's pregnant with my grandson, but my grandson may be blind, may not be able to walk, wheelchair bound. We don't know if he'll live once she has him.
A situation she says no one should be forced into.
It should have been left up to the family. Because I'm in my 50s, her dad is in his 50s, so we're going to have the responsibility with her partner to raise her sons, you know. And I'm not saying that we would have chose to terminate her pregnancy. What I'm saying is we should have had a choice.
So mom says that, of course, this feels like torture. She has to come to the hospital to see her daughter breathing on this ventilator, knowing that she's, quote, not there. So Kenton, let's talk about Georgia's heartbeat law. What does that exactly mean?
Okay, so it's the Georgia fetal heartbeat law. So basically that really what it goes in depth is that it grants personhood to a fetus at the point when a heartbeat is detected. And that's approximately 6 weeks, which for most or many women, they don't even know they're pregnant until they're almost 12 weeks.
Right.
So this is at a very, very early stage. Doesn't have any issue to deal with any issue of viability and so forth. So basically what it does is that it states that at that point, the fetus has now achieved personhood and all the rights that go with it. And subsequently, anything that then has to do with abortion, it then blocks it. So basically, abortions are effectively blocked at 6 weeks. How this impacts the case is that you have a young mother who is legally dead. And because she's legally dead, and she had no healthcare proxy, in which most
Or brain dead.
but that makes her legally dead. That's what it in Georgia. And she has no healthcare proxy and any advance directives and so forth. But this is what's interesting is that with the granting of personhood to a fetus starting at 6 weeks, then even if you had an advance directive, that would not be enough. So for example, if she had in her advance directive that she said, if in case of a catastrophic illness and I'm incapacitated, I no longer wish to be artificially sustained.
Right.
With this giving personhood, but she's pregnant, giving personhood to the fetus, the rights of the fetus overrides her advance directive. And that's exactly in the sense this happened here. Even though and furthermore, since she didn't have it.
Right, because keep in mind, she was only 30 years old.
30
How
years
many
old.
of us at 30 or even 40 or even 50 have advanced directives?
Advanced directives, healthcare proxies design. So we just assume that things will take care of itself. And this highlights that type of conflict. And even if she did have it, though, it wouldn't even be enough. Because the fetal heartbeat law supersedes that. Okay. And that's really what the case is here, is that so she's technically is just being sustained, kept alive in order for the hospital not to be in violation of that law, because since it has personhood, if they fail to do everything they can to keep the fetus alive, they could be criminally charged with feticide, which is a form of homicide, of murdering a child.
Right, but we can understand the point of view of the parents and the point of view of maybe even her partner. Because keep in mind, when she was determined to be brain dead, she was only 9 weeks pregnant. And as we know, 9 weeks pregnancy, which is roughly a week plus 2 months, is not viable with life. It seems reasonable that a family would not have wanted her kept alive when in fact, if she was allowed to pass away peacefully, naturally.
Well, we don't know that because the mother didn't even raise that issue. Her issue is that she wasn't consulted.
Right, she wasn't consulted. Well, because really the flip is she feels like they are keeping her daughter alive or keeping her on a machine artificially, just to deliver a baby that they don't know will A, survive, or B, not have severe medical problems.
Right, but see, let's look at how that law would impact that. So just say hypothetically, right, that the mother was granted guardianship, basically then have the power to make the determinations to continue care and stuff like that. Hypothetically, think about that and say, okay, so let's go and say, what if she did have that? Say this young woman had a will and she granted complete administrative estate, and also in the case of her incapacitation, she had a living will. Okay, because that's what you can have. Because you can say she's legally dead, but she's alive, so she's in this zone here. So you only have a will in case of your death, but say you also have a living will in case of your incapacitation. Say she had that. She gave her mother complete administration and guardianship of her estate, as well as all power of attorney. Even if she had all that and she had ultimate decision, the Georgia fetal heartbeat law would override that. Because she could not make a decision that is contrary to the health and welfare of the fetus. She couldn't even remove care if she wanted to.
Right. But that's not how it is in every state or in North Carolina, is it?
No, it's a state by state. Yeah. So in North Carolina, it's different. In North Carolina, abortions are banned at 12 weeks, but the fetus is not granted personhood. So again, the mother, if she has an advance directive and or a living will and wants to have care removed, that would be honored, okay? Because there's no law that would supersede that. So patient autonomy in North Carolina would be affected, would be basically enforced. Because again, the fetus is not viable.
Right.
It's linked to the mother. So patient autonomy, and then in North Carolina, again, even if you didn't have a living will, the family, the nuclear unit of the family, would be intact, and so they are involved in the decision making and the care. So the outcome would be vastly different in North Carolina than Georgia, because again, the critical piece in this is the granting of personhood and all the rights that are attached to it legally to the fetus, and so the hospital is placed in a rock and a hard place that, again, to not be criminally sanctioned for murder, which could happen, they are obligated to ensure that the fetus is maintained and cared for. So the state grants these rights, and so this is where the thing is until there's a challenge to legal guardianship. But even if there is a challenge to legal guardianship, say the mother says, I want to become a legal guardian.
You mean the grandmother?
Or grandmother. It's the mother or grandmother?
Right. The daughter's mom is alive.
Well, so it's the mother. It's the mother of the daughter. So it's not. So if the mother of the patient, of the daughter, wants to exert her parental rights on her daughter, and she has to seek guardianship. But even again, going back to the initial hypo that we talked about, even if she had guardianship, the fetal heartbeat law would supersede that, because she cannot withdraw care that would harm the fetus. So the hospital is on the hook to basically ensure the welfare of the fetus to the best of its ability, and to get it to some form of viability.
What's interesting is I wish these hospitals had the same energy when that woman walked into the hospital complaining of a headache and they decided not to give her, the best care. You know what I mean? Like, it's so interesting how they will tell you about the law, how they try to impose all of these, what feels like restrictions in the law, when the reality is a young Black woman walked into a hospital, did not get the best care, and now, unfortunately, her family will have to suffer for it. Because the other thing we're not talking about is, so let's say this baby does survive. Let's say this baby has medical concerns or has medical complications. Who is paying for that care? Who is going to be responsible for that child?
Well, who's going to be responsible for the child once the child is basically released from the hospital, survives this ordeal, is going to be then who is the direct family member, which is going to be the father, if there is a father in the picture, her partner or whoever it is, the actual father,
and the grandparents,
or the grandparents if they assume care. If not, then the child becomes a ward of the state.
Wow. And what's crazy is, keep in mind, the grandparents feel like they were not given an option. So it's almost like,
well, technically they don't have an option.
Right.
See, this is, and I think that's part of what the reporting fails to say is that really is that they technically they're.
but it's their daughter.
But it's again, I'm not disagreeing. That's the ethical piece, and that's also a concern piece. Could the hospital do a better job? Absolutely, in communicating things. Could the hospital at least bring them in to have these kind of discussions? And I think that's also part of it too. Is that I see both sides of it. The hospital's put into a tough spot because, again, of the way the law is written, and they're trying to walk this fine line between compassionate care and also following the law, and not to become basically vulnerable to prosecutorial charges. But on the other hand, while you're
Right.
in this mire, you can't forget that this is still a person that has a family that has, and that's part of compassionate care, is that you got to take a look at everything, not just your own interests as an institution,
Right.
and protecting your staff and your team and the bottom line, but it's also thinking about the community as well, because the hospital doesn't exist on its own. It's also embedded in part of the community, and therefore needs to be responsive. And I think that's also part of the learning lesson as well in managing these type of crises.
Because clearly, the mother of the lady who is brain dead clearly feels like her concerns were not listened to or met,
right.
or she did not feel a part of the process.
So if you're listening to what she's saying, though, she
Right.
doesn't feel. So that tells you right there is that it's not about, again, the outcome's going to end up being the same, because again, you have a law that's very, very draconian in the way. And then if you really think and walk through these steps, wouldn't matter if she had guardianship.
So you do
Wouldn't
feel
matter.
like it's draconian.
Well, I mean, personally, I think it's very. It's going to. This just shows you the complexity that this introduces without any of the back end.
Right.
It's like many times that you want to achieve something, but then you take a shotgun approach, and then you just kind of like, well, whatever happens, happens. But this is what we're going to do. When you're not really being comprehensive about it, and because you didn't take into the thoughts of all these other players or stakeholders in the process,
Right.
the family members, them, and not discounting them because of either their education or their social status and stuff. And many times it's those things that creates more of a problem than it should be. And I think this is something that Emory University should step back, and especially I believe as a teaching hospital, should step back and look at how do we make better decisions, or make the best decision, but make it where we are involving and we're not just closing the doors and just to protect our own. I think that's where it becomes more of a crisis than it needs to be.
And it also goes back to the law.
Well, the law, I mean,
Right, it also goes
whereas
back to
like,
those-
again, like in North Carolina, the outcome would be completely different. If she was in North Carolina, there are a couple possibilities, but one is that because if she had that, then the family members have been brought in, they would have been laid out, hey, what would you like to do?
Right.
And they would have a discussion, if we sustain her, but the fetus is not viable, and we're so sorry for your loss. And then
Right.
you make the plans to say goodbye. You would do the things that you
Right.
would need to do, because it's not technically an abortion. See, the thing is,
Exactly.
because we
That's
don't
where
have-
I'm coming from.
because again, we don't allow abortions in North Carolina past 12 weeks. She was past 12 weeks, right? So,
Well, when she initially was
just
found to
14
be,
weeks.
she was 9 weeks.
she was 9 weeks.
Yeah, when the whole headache situation
All right.
and she was declared brain dead, she was 9 weeks.
Okay, so even then, so that would nullify that. But say even if
She's
she was
21 weeks
but
now.
say if she was 14 weeks, again hypothetically.
Okay.
In North Carolina, though, because of that incident, it's not technically an abortion. The
Right.
issue is that we don't grant personhood to the fetus, so they're attached to the mother.
Right.
Okay, until they become viable.
Right.
Right. Then it becomes more of like, can we save the baby and stuff? But you can't save a 9-week fetus.
Right.
Right. So
Right. So in terms of cost and money,
it's astronomical.
right.
So-
Keeping a woman alive on a ventilator, who's brain dead, for 5, 6, 7 months, even though it's not unheard of for people, for example, to be in a coma, which also raises the issue how is, being in this brain dead situation different from a coma? Some people may want to know. If you're in a coma, you're also unconscious, just like being brain dead. But
you still have brain activity.
Right. If you're in a coma, you have some reflexes that are still possible.
Yeah, you still have.
You may still blink. You may even move your eyes if light is shined.
Yeah.
So obviously your brain stem and your brain is still working, but you're in a coma, and it's not a permanent situation. You may come out of a coma. Whereas in this situation, being brain dead suggests that this is irreversible brain damage. You're never coming out. You don't have any reflexes. If they turn off that ventilator, you will stop breathing. And in fact, part of the criteria for judging whether a person is brain dead or not is they do an apnea test where they turn off briefly the ventilator to see if you're breathing or not, and turn it back on when it's clear you're not before, then they inform your family, etc. But there are a lot of tests that are done typically to determine brain dead. Anyway.
Yeah, no, exactly. So that's the thing. So if she's, again, brain dead, then she's legally dead. Right. Until she's, officiated, meaning that they've stopped the machine. So she's artificially kept alive to, again, preserve the life of the fetus until it comes to viability or near term.
All right, just want to know your thoughts on this controversial matter, and it also raises, thought about having advanced directives, also thinking about what happens when something bad happens to you and who is going to be in charge of making life decisions for you or for your children. Or depending on what state you're in, maybe your family doesn't even have a choice.
Yeah,
right?
Right. So that's why it's important to, what these things highlight is that many things that we've taken for granted that as just due course, we have to now start to really reconsider these things and have those type of conversations, even with people that you would think that this is something that pertains to people in their 60s, 70s, 80s. No, it's really something that people at all stages of their life have to sit down and kind of really think about it, even if it's informal, but at least express those things. Ideally, you want to memorialize them in some way, either in writing, in a video, even if it's just something their own voice recorder or digital recorder, but something to at least be able to express, so that way it can be shared to different healthcare providers as well as to the courts. Yeah.
Right. All right, folks, thank you for listening, and drop your comments below. Want to hear what you think about this case. Okay, we'll talk later. Bye.